5, 4, 3, 2, 1.
This Honorable Court of Tennessee is now in session.
Thank you, Ms. Kraft. Thank you, gentlemen. I want to tell you how much we appreciate you and your clients agreeing to participate by way of Zoom oral argument today. It's not our preferred way of doing this, but based upon the circumstances that currently exist, we think it's the safest and best way to do it. Having said that, though, both of you are experienced practitioners. You understand what the rules and the protocol of the court are. And so consequently, I just want to remind you that we will be conducting this oral argument today as if we were all in the courtroom. What that means for your part primarily is that each of you will receive 15 minutes to make your oral argument. If you're the appellate and you've reserved time beforehand, then you will receive that rebuttal time at the end of the appellee's argument. In order for everybody to know who the players are today, let me introduce your panel. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Kraft, anything before we begin oral argument?
No, Your Honor.
You may call the case then.
Regions Commercial Equipment Finance LLC versus Richards Aviation Incorporated.
And thank you. And we will now hear from the appellant.
Thank you, Judge Stafford, Your Honors. Jake Brown from the Memphis Bar. Madam Clerk, if I may reserve 3 minutes for rebuttal. It looks like that's already reflected.
Yes, sir, it is.
May it please the court. Your Honors, as I was preparing for this argument, indeed while I was briefing this appeal and preparing for this oral argument, I found myself retreading much of the same argument that I made the last time that Mr. Shelton and I appeared in this forum on this case. And that is because the issue is largely the same. Then last night, I listened to a recording of our oral argument from when that was held in November 2018. And one distinction emerged. That is, when we previously argued the case, I strove to distinguish the facts before the court then from the precedent that controls on this question. That's the question of what Rule 56.04 requires. And when we were previously before the court, we relied on Smith versus UHC Health Services and Battery Alliance versus Allegiant Power. But my goal there in the previous time we were here was to distinguish our case because unlike the facts in those two authorities, we were before the court with essentially no ruling to go on from anyone. Here, the facts are much similar to the fact patterns in those two cases. Specifically, this is an instance when the document purporting to be the judgment, granting summary judgment of the trial court was not in fact authored by the trial court. It was authored word for word by plaintiff's counsel. And the law is very clear in this state that this is not appropriate under Rule 56.04. The reason, so to review the history briefly of Rule 56.04, in 2002, that part of the rules of civil procedure were amended to require a trial court to give its reasons for stating or for
let me interrupt you. I have a question about the contempt. Is your client still in contempt in this court?
Your Honor, we believe no. That's not my understanding.
Well, has the contempt, have you ever resolved the contempt?
Well, Your Honor,
That's a simple question. Yes or no? Have you?
I believe we have, Your Honor. I believe, in fact, that this court resolved that contempt prior to its being granted. The only issue of contempt that was raised, other than the contempt for which sanctions were imposed on January 25th, 2019, there was another ruling of contempt that the court entered on May 15th, 2019. And we have, now at the time that was entered, there were no sanctions imposed. And based on the research I did at the time, that meant that it was not ripe for appeal. So we did not challenge it unless and until it would come up again. But we did dispute it, and we disputed it at more length when, following our notice of appeal in this case, we subsequently responded to plaintiff's motion to alter or amend. But the issue, Your Honors, was this: in early April, so after there had been an issue with a certain customer list that our client had been ordered to produce unredacted, and admittedly, he failed to do that within the time required, and sanctions were imposed for that. Subsequently, there was another order compelling Richards to produce a customer list. Now, importantly, this was in connection with execution proceedings on summary judgment, which at the time there was still an appeal pending. We had not posted a supersedeas bond, and we had never disputed the court's authority, the trial court's authority at that time, to compel production in aid of execution. However, this customer list was ordered to be produced by no later than May 14th, 2019. On April 30th, so prior to that deadline, on April 30th, the vacator from this court as to the first summary judgment ruling came down, wiping out that judgment. So there was no longer a judgment on which to execute. And we maintained that, therefore, because the court's ancillary jurisdiction to compel discovery in aid of execution is predicated on a valid final judgment, it was our position that we were no longer under an obligation to produce that customer list in aid of plaintiff's execution unless and until there was another judgment entered. And that was, it was for that failure of production, or alleged failure of production, that the court on May 15th said it was finding Richards in contempt, but withholding the question of sanctions.
All right.
So our position is that there really never has been a contempt other than the contempt order on January 25th, 2019, for which our client has been sanctioned. The importance, the requirements that a court, not a party, but a court must state the grounds for its ruling prior to instructing a prevailing party to draw up an order on the question. And this court and the Tennessee Supreme Court have noted that the practice of allowing parties or asking parties to draft up orders is disfavored, although under certain circumstances, like on a crowded docket, like on the 30th Judicial District, it's accepted. However, in those cases where a party is instructed to draw up a summary judgment order, the law is very clear that the court must give its reasons for granting summary judgment prior to asking that party to draw up the order. And the purpose is straightforward for that requirement. It's so that the parties can be sure, this court can be sure, that the order the court is making reflects its own independent judgment. And that's the problem we have here in a situation where the court just adopted an order submitted by opposing counsel wholesale. And the situation is even more egregious here, because at the time the court announced it was adopting the proposed findings of fact and conclusions of law, there was no summary judgment pending, no summary judgment motion pending. I was going to return to May 2019. There were the contempt and discovery native execution questions. There was also a question about how to proceed at the trial level in this case following the vacator. On May 29th, 2019, the parties appeared before the trial court for a status conference on the question of how to proceed. We maintained, defendant Richards maintained, that the court was required to give some further consideration to the question. And particularly since by that time, in the intervening 30 days since the vacator, we had filed notices of deposition and a motion to vacate all post-judgment discovery post-judgment discovery orders. We maintained that the order required that the order from this court, opinion from this court, required something more than the mere re-entry of an order granting summary judgment. That status conference ended with the parties disagreeing as to how the case was supposed to proceed and what the Court of Appeals requested or wanted from the trial court. And the parties were instructed to draw up competing orders on that question. Importantly, not the question of summary judgment. We concede that under certain circumstances, a trial court may ask the parties for competing orders on a summary judgment question, particularly when the issues are particularly intricate and complicated, or when you have a multitude of issues. We understand that sometimes those competing orders can assist the trial court in making its ruling. The problem here was that the trial court had not instructed the parties to submit competing orders on the summary judgment question. It instructed them to submit competing orders as to what the first opinion of this court required in terms of how to proceed in the case. And when the parties received the announcement from the trial court's clerk, that was the first we had heard that the court was considering summary judgment. It never gave us the opportunity to submit competing findings of fact or conclusions of law. We didn't know the question was pending. And Your Honors, I would point out that this court's instructions.
So let me ask you a question, Mr. Brown. Are you raising as an issue the trial court's resolution of the case when it was remanded from the Court of Appeals?
I'm not sure what Your Honor's asking.
Well, you just said that there was a dispute about what the Court of Appeals asked the trial court to do, and that both of you disagreed, or both parties disagreed about what the trial court was supposed to do when the case was remanded. Is that part of the appeal of this case?
Your Honor, I see. I will answer your question.
You may go ahead and answer the question.
Your Honor, I would say that question never got before this court, because instead of ruling
when you say this court, which court are you talking about? Before
Your Honors, before the Court of Appeals, that question is not properly before this court because we never really got a ruling on it. While we understood the question of how to proceed was pending, the trial court determined it was just going to re-grant summary judgment.
So that's not part of what we're to consider, not part of the issue that you have raised. Is that correct?
That's correct, Your Honor. The issue, we believe that this is a narrow procedural question of whether the trial court complied with Rule 56.04 as it was instructed to do by this court on previous remand.
All right. Thank you. Thank you. We will hear from Appellee's Counsel now.
Thank you, Your Honor. For the record, Hank Shelton of Memphis Bar, representing Regis Commercial Equipment Finance. Let me begin, if I can, by addressing the issue raised by Judge Golden, and that is Richard still in contempt? I think the answer, no, I don't think the answer, I represent to the court that the answer is yes, Richards is still in contempt. I direct the court's attention to the supplement to the record, which was according to the electronic docket filed on April the 8th. And specifically page 49 of that supplemental record, which is the court's own, and I stress own, order denying plaintiff's amended motion for sanctions and contempt and to alter or amend judgment. It's an important order for several reasons, and I'm glad it's in the record now. In that order, Chancellor Evans pretty explicitly held that Richards was in contempt of court. The contempt for the panel actually relates to discovery carried out in aid of execution under Rule 69 following the entry of summary judgment and pending the first appeal in this case. To make a very, very long and complicated story very simple, Richard's principal did not want to cooperate with the discovery request, refused to cooperate with the discovery, refused to cooperate with the court's orders requiring discovery, repeatedly refused to do so, was held in contempt, and sanctions were reserved. The reason this order is important is after the entry of the amended order on summary judgment, we pursued this, our motion to hold Richards in contempt, and sought additional sanctions, the sanctions basically being striking the answer, so that his contempt would, in the eyes of the trial court, be an additional grounds for granting summary judgment. Chancellor Evans frankly refused to do it. He outlined in great detail the defendant's post-judgment contempt, which of course is contempt under the Fry versus Fry case, which I think came out of this section, but said he wanted this panel to take, to have only his ruling on the amended summary judgment order and not be, well, let me read the court's own words, because I think maybe the chancellor did it better than I could. So pardon me for reading into the record. The parties' positions as to if sanctions were properly granted, and if so, what they ought to be, were well argued by counsel. However, the court is of the opinion that the sanction requested, that the defendant's answer be struck from the record and default judgment granted, is not appropriate. No further determinations are needed, as all other issues and questions are moot. This case has come to its natural conclusion in this court by the entry of the amended order granting summary judgment, which clearly outlines the opinion of this court as to how and why it reached its legal conclusion. Striking the defendant's answer at this stage in the litigation serves only one purpose: to deny the Court of Appeals the opportunity to review the complete case record, including the answer, which, being a pleading in the record, this court reviewed and in some degree relied on as it came to its decision. With humility and respect for the processes of the Tennessee judiciary, this court is not inclined to prevent the Court of Appeals from doing so as well. I wish he granted sanctions. It would frankly make it easier to distinguish Smith and Battery Alliance, as we're required to do, but I've got to do what the trial court ordered me to.
So let me ask you a question, Mr. Shelton. When did the trial court take up this contempt issue?
Oh, at least 3 or 4 times post-judgment, Your Honor.
Post-judgment. You keep using the word post-judgment. So you're talking about the last time the you're talking about the new summary judgment the trial court entered. Is that correct?
No, sir. No, sir. The original summary judgment, and I'm going on an old man's memory here, was entered, I think, February 16th of 2019, if I remember correctly. Richards promptly appealed. They were unable to post a supersedious bond. That gave Regents the right to conduct post-judgment discovery. The post-judgment discovery I'm talking about occurred between the end of this stay under Rule 69 and this court's opinion on the first summary judgment motion, which I believe was entered April 19 of 2020.
I
So-
believe it was entered before then.
Might well have been, Your Honor.
I think it was in 2019.
Could have been.
Actually, it was filed April 30th, 2019. So
Oh, that
I'm
case
trying
might-
to figure out is if you don't have a judgment, which as of April the 30th, 2019,
Yes, sir.
how can they be in contempt for failing to comply with the judgment?
Because this court and other courts have repeatedly held that even if a judgment is voided or vacated on appeal, a party is obligated to honor it, failing which the party.
Until it's vacated.
No, Your Honor. Not at all. If Your Honor looks at the Fry versus Fry case, I don't think we cited it in the brief, but it's as I understand it, good law. If a party.
It's going to be difficult for me to understand if the Court of Appeals has vacated a judgment and the parties are aware and the court's aware, and then the trial court is asked to hold somebody in contempt because of that judgment that's been vacated. It's going to be a difficult sell for me, but you go ahead.
Your Honor, it would be a difficult sell. And as I said, I'm dealing with an old man's memory here, so forgive me on the dates. Let me go back to the motion, which is also in the technical record, which sets forth the dates with some accuracy. The summary judgment was entered December 2, 2016. This court's order vacating was entered, as the court indicated, in April of 2019. The contempt that we're talking about occurred between December 2, 2016 and this court's order and opinion in what Mr. Brown has called Regents 1. So all the contempt occurred prior to this court's vacating anything. And during that time period, from December of 2016 until April of 2019, there was a lot of discovery done. There were a lot of contempt hearings done, and several orders of contempt were issued in that time period. Now, the law, I think, Your Honor, is quite clear. While this court vacated the original summary judgment order, anything that occurred between the entry of that summary judgment order and any orders rather issued by the Chancery Court between the entry of that summary judgment order and the court's vacation of that same order are valid. And the defendant was required to obey those orders, and the defendant did not. And the defendant was found in contempt and still did not. And the defendant was found in contempt and still did not. So the only issue that was left hanging after Your Honor's opinion, or actually Judge Jenkins' opinion, in April of 2019 was the sanctions to be granted for the defendant's refusal to obey valid orders during the time that the court had jurisdiction to enforce its discovery.
Okay, now which specific order are you raising?
The order I just referred to was entered on our motion for sanctions after the amended order of summary judgment was granted. So the date on this order, I think, was May 20 of this year. As I said, it's page 49 of the supplemental record.
May 20th of which year?
21, I believe, Your Honor. Or 20, I'm sorry. May 9, 20, no, that's our motion was filed May of 19 for sanctions. And the court's order to which I referred, pardon me, Your Honor, I'm flipping through the record, was signed by Chancellor Evans, his own order, as I indicated, on August 31, 2020. So, and it was disposing of motions that were pending before the vacation. Now, I've got 4 minutes left to address what I think is the heart of this appeal, if I may do so. And that is.
Well, hold on just a second. You got me confused. Notice of appeal was filed March 9, 2020.
Yes, sir.
And you're saying this order was entered what day now?
May of 2020.
Okay.
It was filed as a motion to alter or amend prior to the filing the notice of appeal, I believe, within 30 days of the amended order of summary judgment. So it's a timely motion to alter or amend. It's simply not disposed of until after the notice of appeal was granted.
Okay.
Odd way to do it, but not my call. Now, if I can briefly, in the few minutes I've got left, may it please the court, let me simply address the issue of authorship. We've talked about Smith, which was, of course, the highly complex medical malpractice case that went to our Supreme Court and gave rise to the rules that we're talking about on Rule 5604. What Smith said, and I'm quoting Smith through Judge Frierson's recent opinion in Highlands Physicians, which is by the Eastern Section of this court, 2020 Westlaw 575-4574, said, quoting Smith, that reviewing courts have declined to accept findings when the record provides no insight into the trial court's decision-making process, and then an or clause, or when the record casts doubt on whether the trial court conducted its own independent review or that the opinion is the product of its own judgment. What we have in this situation, may it please the court, is a case where it's on the record. The trial court asked for orders. We submitted proposed findings on summary judgment. Some time went by. The court indicated by email that it was granting the summary judgment based upon the plaintiff's, that is, region's proposed language. The court adopted it as its own language, rather emphatically. A string of emails followed where the court repeated several times, "This is my work, I'm affirming it." And then finally, as I just read to the court a few minutes ago, in his order of August 31, 2020, the trial court said emphatically, "This is my work, I adopt it." Basically, I like the way they wrote it, and this is what I want to say, and this is what I said. Just about that plainly, just about that explicitly. So in this case, unlike Smith, and if the court remembers the fact pattern in Smith, the trial court heard an extraordinarily complex medical malpractice case and said, "I grant it, you go prepare the order," and then the defense counsel prepared, I think, a 40 or 50-page summary judgment order, which the trial court then immediately signed. This is not that case. In this case, this chancellor said repeatedly, "The plaintiff might have written it, but they're my thoughts, my words." So you have the word of an honest chancellor saying, "This is what I meant to say, this is what I said." And that, I think, complies with Smith. And if there are no questions, my time is up. Thank you.
All right. Thank you, Mr. Shelton. Mr. Brown, you've got rebuttal time.
Thank you, Your Honor. May it please the court. I want to start out actually by agreeing with something that Mr. Shelton just said, and that is that this case is not Highlands Physicians. And the relevant distinction, we believe, is that in Highlands Physicians, the court solicited competing orders on the summary judgment question. Had the court done that here, this would be a very different case, but it did not. The court.
Why would it be different if the trial court never said how it was deciding anything, or was never expressed what it was concerned about or any of its reasoning?
Well, Your Honor, that's a good question. I may have misspoken in saying it would be a very different case, or a very different case. It would have been a different case in that it would have matched relatively closely the fact pattern in Highlands Physician. But the difference, the key difference here is that we didn't even get that close. We weren't even, there were no competing orders solicited on the summary judgment question. Does that answer Your Honor's question? I'm not sure.
I'm just following what you said. I was curious why that worked. Go ahead.
Well, Your Honor, we certainly did not decide Highlands Physicians. We accepted it's settled law, and we understand that under certain circumstances, such as the fact pattern that Mr. Shelton just articulated, highly complex case, lots of outstanding issues, we would concede that under certain conditions, it's acceptable for a trial court to say, send me competing orders on this summary judgment question. In fact, I think in the Highlands Physicians case, the court actually announced on the record, told counsel that, look, I know this is not always acceptable in the summary judgment context, but I'm asking you to do this because this is a very complex case and it helps me, the trial court, in making my ruling. Okay. Sometimes maybe it's okay, but that's not what happened here.
Well, let me ask you about something Mr. Shelton said. He said that the trial court on more than one occasion basically said, this is my order. I have said what I wanted to say in this order. Is that correct? Does the record bear that out?
The record bears out that on August 31st, 2021, 6 months after the trial court granted summary judgment, it said something to the effect, yes, that, oh yeah, that order I entered previously reflects my reasoning. But he did not, but that certainly does not meet the requirement from Smith and Battery Alliance that the trial court give its answers for granting or denying summary judgment prior to instructing counsel to draw up the order.
All right. Thank you.
Thank you, Your Honor.
Gentlemen, we again appreciate you working with us and agreeing to conduct Zoom oral arguments. And we will endeavor to get you an opinion at the earliest possible time. Thank you.
Thank you, Your Honor.
And Ms. Kraft, if you will recess court to the call of the docket tomorrow.
This honorable court of Tennessee stands adjourned.